In today's video, we're going to be talking about inheritance of a property when your spouse passed away. What happens when your spouse had a previous marriage? Do your kids inherit the property? What if your kids are still minors? How does that work out in Texas? We're then going to go through two example scenarios that will help clarify a little bit further how this would be handled in Texas. My name is Aaron White. I'm a realtor with the A-List team. I've been working in real estate for well over 10 years. And this video will go through how we've seen with our clients as we've progressed through similar situations in the past. All right, before we go into scenarios, it's important to understand a few definitions on how Texas looks at property based on the time of your marriage and the purchase of that property. We want to understand community property and separate property. So first, community property is the default. When you get married, then after your marriage, you buy a house, it's considered community property. And therefore, you and your spouse both own 50% of that property. Now, separate property is in really two scenarios most frequently in Texas. Either A, your spouse purchased a property before you got married, or B, they inherited a property after you've been married, but because it's inheritance, it's considered separate property. With separate property, the spouse who married the spouse who passed away does not have ownership of that property unless that spouse's name or your name was added to the deed prior to the spouse being deceased. If the property is considered separate property, you would need to go through either the typical will or probate process or affidavit of heirship process in Texas and divide it according to that standard. For the sake of this video, we're going to assume that you do not have a will. If the deceased left a will, the will will outline exactly who they expect to own that property, and none of this really matters. The will is what prevails. You will need to go through the probate process and follow that. It's a judicial process in owning real estate, and that will outline who owns what. Both of these scenarios that we're going to outline, we're going to assume that the deceased did not leave a will. In the first scenario, you have John and Mary. John had previously been married to a different person and they got a divorce. However, they did not have any kids in that marriage. John then married Mary. Mary and John had 2 kids. And in that scenario, because there's no other kids in another marriage, Mary would actually inherit the entire home upon John's death. So if John were to pass away, there would be no split in the inheritance, and Mary also would have the full ownership even though she still has kids. In scenario 2, John has 2 kids in a previous marriage. Then he marries Mary, and then they have 1 kid together. Now this is a little bit different. If John were to pass away, then that property is divided 50-50 according to this. So Mary would get 50% of the property, even though they bought that property after they got married. And then the other half would be split evenly amongst all 3 kids. Even though the kids are in different marriages, one with Mary and one that was in a previous marriage, those kids technically still have inheritance rights to that property in Texas. Now you might be wondering what happens if one of those kids is a minor. Well, minors cannot buy and sell real estate. They cannot sign a contract until they are 18 years old or older. So in Texas, they would need to be appointed a guardian that would be taking care of their interests, financial interests, and be able to sign the sale of a property. And in that case, you do need to go through a probate court to have a proper guardian assigned. And I'm sure you can understand why, simply because you're commonly dealing with maybe a former spouse or other individual that's involved, and you may not have entire full control or knowledge of that. So a judge needs to go through the process of understanding the situation for that family and appointing that guardian that will ultimately care for the interests of the heirs. I know for many, they may not agree with how Texas divides real estate. That being said, Texas has to have a standard process to handle these situations, and that's how it is applied today in Texas. If you want to make sure that your inheritance in the future for your heirs in the future do not face a similar situation, it's important that you do some planning. You can work with an attorney to write up a will or write up a living trust that will outline exactly how and who will inherit the property and ultimately make sure that your wishes are abided by when you pass away. It might take a little more time for your family, but it makes a lot easier on the family knowing that your wishes are being abided by and the inheritance is being divided how you planned it. As I mentioned, my name is Aaron White. I'm a realtor with the A-List team. If we can help you answer any questions on how this works in Texas, please reach out to us on our website or give us a call. Be glad to help you. We'll see you at the closing table.